Welcome to part 2 of this episode with Lois Norris, where we're talking about fundamental dishonesty and how that links in with recovery and rehabilitation. So if you've already listened to part 1, you'll have heard Lois talking about dishonesty in itself and what it means and how something can be termed as being dishonest in a claim. And then she talks to us about how the case law has developed and how we ended up at a point where fundamental dishonesty is even a consideration.
Yeah, so in the second half today, Lois continues that discussion, but also shares a little bit more about her role, the role of a barrister, demystifying some things as we mentioned at the end of part 1. So really hope people are looking forward to that. And without further ado, here's part 2.
One of the things I wanted to mention to you, Lois, it's just a really interesting phenomenon that I think maybe you might be able to speak to as well, Ben. It's this idea that somebody who has been injured might go and be assessed by a medical professional and want that professional to believe them, and so they might present their symptoms in a way which could be argued is exaggerated. I think it's called white coat syndrome?
Yeah, it's a really great point, Patrick. I think I was mulling over lots of themes there, because if you think of the word inconsistency, that's different to dishonest. Inconsistency, and I think you made the point, Lois. And what I was reflecting on, I did some training and some teaching recently where I always use the same example. If I said to you, what did you have to eat on the 15th of August 2007, you probably wouldn't remember. But if I asked you what you were doing on September 11th, 2001, most people have almost like a film with all the senses, sensations, memory of that day. That example's working less well now that I'm getting older, because I've had a few people say I wasn't born in 2001 or I was 2 years old. But I think most people, when I ask that example, it's like they can tell me, drip by drip, exactly what happened on September 11th, 2001. And for lots of our clients, they experience inconsistency because of the emotional roller coaster of life, of the process, of recovery. And even as you were talking there, Patrick, about sort of white coat syndrome, which I think the best example of that is like heart rate increasing when you see a doctor, or another symptom getting worse, or because it's like an attentional bias, isn't it? Like if I got our listeners now to think about blinking, you're all thinking about blinking. It's not that your blinking is better or worse than it was before. It's just I've asked you to think about it. So it's tricky. This is my conclusion about. And it is that split between, I liked how you said earlier, Lois, that's the fundamental dishonesty, isn't it? It has to be fundamental. Is that how you would explain it as well? Like it has to be really demonstrate that it's fundamental and its root cause, as you said earlier.
Yeah, so nobody is going to suggest somebody is fundamentally dishonest if there's a slight difference between two reports. And in fact, my view is that reports will have natural differences in, and we can try and fine-tune everything, but judges are human as well. I think the problem is if it becomes horribly inconsistent throughout, then you can't work out where the lay of the land is, or you've got two completely different narratives, then that's where it becomes fundamental into the root of the presentation of the claim. So if we take the example earlier of I never go out the house, if you're going out once, as I say, that may be different. But if you're going out 3 times a day and you're saying I never go out the house, they're very hard to correlate, those two things. And so, yeah, it's not, you don't want to go in, you're not rehearsed, you shouldn't be rehearsed, you're a person. But I think you've got to think the presentation of the case. And the presentation of the claimant's life needs to be real and raw and vulnerable. And that's hard, but that's what you've got to do. Because the best way that a judge can assess what you need, what a claimant needs for the rest of their life, is to properly understand what that life looks like. And so really what we're asking claimants to do in the aftermath of something really serious happening is also to bear absolutely all to loads of strangers. And when I first go into a house with a claimant, I appreciate, firstly, that I'm in their house, I'm in their personal space. I'm sat there in my suit and heels on their sofa. And secondly, that I'm asking them to talk to me about their most intimate problems that they have. And they met me 10 minutes ago. And so we're asking claimants to be brave with that, I think. And I think what we have to do is explain this process is horribly invasive, but I can't change that because I have to make sure you have enough money for the rest of your life and for your needs and for your rehab. But what I need from you is for you to just bear it all. And that's really hard. And you're really brave for doing that, but you have to do it. Because otherwise, if you've got two different narratives and people see people and, if I'm having a rubbish day and I see someone in chambers, I don't normally say that. I say, I'm really good, thank you. How are you? And so we've got to kind of break down those barriers. And that's where the rehab team come in massively as well. Because if the claimant feels comfortable and themselves, then we're more likely to get the real picture.
Yeah, absolutely. And that is very much our role, working as treating clinicians and as case managers to really understand the client and support them day to day with not just the rehabilitation, although that's obviously the main focus. I mean, there's things like litigation stress that clients go through that does have an impact on the way that the client experiences life in general, and that does form a part of our role. And I was thinking there, Lois, when you were talking about, the client having to open themselves up and be just bearing all to this unrelenting process. There's also this idea of the client and their family and even the professionals around them having their integrity questioned. And I think that's a really, really powerful thing. Certainly for me, as a professional, I hold myself to very high standards, as should we all. And the moment that my integrity is questioned, it's painful. It really cuts deep. And that's for me as a professional. So for a client who's living and breathing this every day, for this idea that they may be being questioned and that they're being accused of potentially not telling the truth, I imagine that's going to hit hard.
Yeah, absolutely. And I think there's two elements of it. The first one is, like I said, sometimes people get surveillance and that feels really invasive because it is. And the second part is that if somebody's accusing you of lying, then that's incredibly stressful without the background of a serious injury. And questioning your integrity. The flip side is the process has to do that because the vast, vast, vast majority of people we know are good people. But there are some people who aren't being honest in the system. And so that's why it's there. And I think understanding that and being transparent about it helps. All I can ever say to claimants is this process is horrible. It is. It's really intensive, but we've got to do it. And so that transparency, I think, helps. But absolutely, I mean, integrity for the claimant, integrity, and we'll probably come on to this, Patrick, but for professionals involved. If somebody's questioning your integrity, sometimes unfairly, then absolutely it becomes a deeper thing. It's now not just this case that I have to do before I can get on with my life. It's I'm an innocent victim of what's gone on. And now on top of this, I'm being called a liar. And so, absolutely, I mean, the psychological impact of allegations of fundamental dishonesty is something that's probably not explored and vocalised enough, but it's not ignored.
And sorry, Patrick, it just makes me think, like how do rehab professionals and clinicians navigate this then, Lois? Because you mentioned there about being transparent with claimants from the offset, when you meet them. But how do I navigate this? What do I do? Do I do anything differently? Or is it just do my job, business as usual?
Yeah, so I think there's two questions. There's how do you do anything differently with the claimant? And there's do you do anything differently with your practice? And they're two different things. And I think in terms of the claimant, it's not the professional's job to talk to them about fundamental dishonesty or anything like that, because they should have been informed about that and they should know about it. And I think for professionals around claimants where this is being floated, it feels scary probably for yourselves as well. And I think what you've got to remember is you have a duty to the court. So you do have a duty to the court, but you should just do your job as you normally do. And what does that mean? Well, in your job, if you take a case manager, for example, they may advocate for a claimant in terms of their treatment, and they may need to do that, and they may need to see, no, we need this house isn't right, this therapist isn't quite gelling with the claimant, and that is your job, that is your role. What the role isn't is to try and be an advocate for the claimant in their case, because ultimately, as much as we may get on with claimants, we're there to do our job. And so the first thing I think of is, what are the realms of my role? And once you're in there, you're in your safe place because you know the realm of your role really well. And so you do what you'd normally do. You listen to what a claimant says, but you do your own assessment like you would normally. You think clinically about what somebody needs. And you'll know from your job that what somebody needs sometimes isn't always what they think they need. And so it's just that same process. What does this claimant say? And what do I objectively think this claimant needs and presents with? And I think the big thing, and I always put it in capital letters, scrutiny is part of your job. Scrutiny is part of my job. Scrutiny is part of the judge's job. And you are aimed with a toolkit. And that toolkit is your claimant and what they tell you, but also their family members and also their records. I could sound like a broken record about records. Because if you review the records and say, for example, we're looking at a matter, really personal matter like bowels, a claimant could say to you, oh, it's fine, it's all fine. But the records may reveal a different story. And that happens the other way sometimes. I was struggling with this, but there's a review appointment where everything was said to be fine and the claimant was discharged. It is our job to scrutinise those, both of our spheres, clinicians and professionals around the claimant and lawyers. But that's no different than you would do anyway, because you're assessing what somebody needs and their care and rehab regime. Which I think leads to, and we'll come back to this, but you were talking, Patrick, earlier about your integrity being undermined. I was taught when I was at school to P, it was called, to point to evidence and explain. And I still use that all of the time. And when we're doing our role, whether as clinicians or as lawyers, you need to look at what's there, explain it, and explore it and say, okay, from this, because of this, this is what needs to happen. And so I think probably the only thing I would kind of harp up about, and I'm not here to tell you how to do your job and you're not here to tell me how to do mine, because we wouldn't be good at that, because we do our own. And when I talk about our safe place, we know it. But I think the one thing I would say is that clinicians should never be blinkered in one view. You should do as you do, scrutinise all of the evidence and come to your own objective view.
Yeah, and that really strikes a chord with me. Whenever I'm supervising and training, mentoring new case managers, it's drumming home that message of, if it's not written down, it didn't happen. Record it accurately. A couple of lines isn't enough. Explain it properly. Have you conveyed what you actually mean in your recordings? Including real detail within the recordings is so important. And for example, as a case manager, I might see something, I might spot something with a client in terms of their presentation, so I might notice that that does need to be explained. We need to explore and make sure we have evidence as to why they might be behaving in that way, so then kind of working with the MDT to ensure that we've covered that, so that we're sure what we're looking at here. That's all really important stuff, isn't it? And I guess that's for all of us in the MDT, not just the case manager, to think in that kind of way. What's here that could be misinterpreted? We need to clarify what this is and make sure that we're treating it correctly.
Yeah, absolutely. And you can't control what somebody tells you. And your job isn't to change what somebody tells you or to get involved with that. Your job might be to say that doesn't accord with, my examination. You might record that. But you almost have to be selfish a little bit, because you have to think about your integrity as well.
Yeah.
And a lot of the time, the reality is, claimants, and if I take, I had my godchildren this weekend, and my godson will say, I don't like that. And I'll say, no, you do like that, because when we went here and you had it, you liked it. And I know in the time that it's something that's said that doesn't match, but it's just all about that process, I think, and scrutiny, recording, and remaining independent, because you have to be independent to do this job well.
And I think for me, on that, I think one of the biggest challenges as psychologists, we talked earlier about people bearing the soul, and we're technically people where we save people to bear your soul too. That's my job. That's what I'm here for. And I think one of the biggest challenges then is how do I get you to bear your soul whilst also simultaneously saying I'm going to share this potentially with lots of other people, and that kind of early transparency in the process of what do we mean by sharing and being detailed and being clear, and the person understanding what's being included or what's being shared where. I find that really hard in terms of that early trust building, because it's, from the minute I'm in a room talking to somebody, we're pressing record, so to speak, on this conversation in its form, and trying to gather themes and collecting themes for people that communicate the story, that maintains their safety and security. It's a real challenge, actually. And I think what I'm hearing from what you're saying, and certainly what you said there, Patrick, is it's about showing you're working out, isn't it? But constantly holding the person in mind. This is the constant balance.
Yeah, absolutely. And especially for the professionals working with claimants day to day, the litigation stress that you talked about earlier, trying to manage that already is very difficult. I think transparency and being straightforward. We can't hide from the fact that this process exists. We wish it didn't, but it does. But being transparent about it, you they have to be raw and vulnerable, and that's so hard to do. But if you explain why, and they understand the risks and the consequences, I think that all helps. And unfortunately, the only way for people to assess what they need for the rest of their life is to know what life looks like. And so we've got to know that. And it feels horrible that so many people have to know it, like you say, Ben, and it has to be shared. We can't get round that. We can't get round. I'd hate the idea of someone seeing all my medical records, but that's the process, unfortunately.
Yeah. It goes back to the word you used earlier, Lois, which is fairness. And we talk about fairness in the context of the client getting what they need, but I suppose the legal system is there to ensure there's fairness on both sides. It's not just the claimant getting what they need, but also being fair to any insurer as well. And that's the delicate balance that the court has to make, isn't it?
Yeah, absolutely. And talking about that, I mean, we're talking about claimants, rightly so, because this is about rehab and recovery. But insurers have a different focus a lot of the time, because ultimately it's them who has to pay for these lifelong regimes. And so you can see why they want to scrutinise it as well. But judges have a balancing act to do. And there was a case called Isen and Warner, which was in 2021. That says it was a balancing act between, on the one hand, the extent of the dishonesty, and the other hand, the injustice to the claimant. And what was said is, in my judgment, the culpability and extent of her dishonesty far outweighs any injustice to her in dismissing her claim. The dismissal of this claim seems to me to be exactly the evil to which Parliament directed its mind to in enacting the section. And so they're doing that balancing exercise of weighing up, okay, you lose your claim, but if you've lied about everything, and that's what insurers are doing as well. But it is a balancing act, and again, talking about it in a legal setting and to reassure claimants somewhat, perhaps, I have a code of conduct that I have to abide by, and that says that I must not draft or allege fraud if I do not have clear instructions from my solicitor to do so, and secondly, which is important for us, reasonably credible material, which establishes an arguable case. And that's where our independence is really important at the bar, because if I get sent, we say this claimant is lying, and I look through and go, well, I don't take that view anywhere, and I don't think you've got any material to support it, then I'm independent and I won't be pleading it, because I'm aware of my code of conduct. And going back to what you say, Patrick, our integrity. I'm not going to risk pleading a case on the basis of ruining my own integrity and going against my own code of conduct. So again, when we talk about the balancing act, that applies throughout. I'm not pleading something if I've not got the evidence to point to plead it. And barristers, of course, I'm a predominantly claimant barrister. I probably do, a huge split of work for claimants, but I do sit on the other side of these things. And so you've got to, that's the fairness, I guess. You can't plead it if you've not got anything to plead it with. And a judge has to balance it all up. And that's not a job that I envy.
And I guess what's emerged for me is that theme of ultimately the problem here is people who are fundamentally dishonest. That actually all of us are aiming for the same thing, which is justness and fairness and integrity in all of the process and our clinical work, but ultimately getting what's right for the person who's been involved in a horrible accident or event. And actually what the dawning reality for me, the light bulb moment, is it's the people who are liars and dishonest. That's the problem.
Absolutely. And unfortunately, seriously injured people who aren't dishonest are being punished a little bit for that, because that's why we have this process. But the flip side is there are people who lie, and there are people who say they've got injuries they haven't. But, the vast majority of people are losing because of that. And so they're having to go through this horribly invasive process. But it's balancing, and we've got to do that. It's the process and system we should have in place.
Yeah. I found this discussion really interesting, Lois, because it's shining a light on a different part of what goes on with our clients that we don't necessarily always see from a treating perspective. And it certainly has given me the impetus to kind of think about that a little bit more and ensure that I'm detailing within my recordings everything that I'm seeing and hearing. And like you say, ensuring that everything that I do is totally independent, and that, ultimately for us as clinicians and case managers, we need to be thinking, this case, like you prepare these cases as though they're going to court. We should also do that. And, asking myself the question, if I was to be cross-examined or questioned in court, am I able to actually explain this? Am I able to defend my actions as a case manager and the decisions that I'm making as well?
So how do we move forward with this then? What do you think, what's the direction of travel with fundamental dishonesty going forward? Because I think you've helpfully framed what it is, where we're at, some cases. What do you think needs to change, or what does the future look like?
Yeah, I mean, at the moment there's grumbles about the impact that there is on claimants if somebody alleges for 3 years that someone's fundamentally dishonest on some evidence but little, whether there should be stricter penalties for defendants if they do that. Because one thing we have to think about is if you're a claimant who, your barrister can be saying, I'm not concerned about this, I'm not worried about this, I don't think on balance this is going to lead to fundamental dishonesty, but you've got a defendant offering you a lower sum of money and those allegations go away, then that is a choice some claimants will take. So in the barrister's view, undersettling their claim because they're scared. And I can't stop somebody with capacity doing that. I can say I'm not worried if we go to trial, but they're worried and they're staying up at night thinking about it, and it's their life. And if I've got that judgment wrong, by the way, we've already talked about the implications for that claimant, so you can understand why people do it. But there's a lobbying as such that if it's going to be alleged on little material, then there should be greater penalties for defendants in making those allegations if they're not proven at trial or they're dropped later down the line. And that'll be an interesting one to watch. I think perhaps reinforcing the guidance of how important it is to have credible material is the starting point on that. Where more cases will come up. It is coming up more. When fundamental dishonesty first started to rear its head, I think if you ask most solicitors and barristers, they'll say it was in whiplash-esque claims, so lower value, short duration injuries. It has absolutely found its way into serious injury, and we're dealing with the very real day-to-day of that at the moment. So there will inevitably be more cases. And there'll be more cases both ways because every judge is different. And we've talked about how broad those definitions are. It's the judge who's going to have to decide that. More decisions equals more guidance for the test, but also more guidance for people around the claimant, for those professionals. And you'll see what judges scrutinise. And then I guess you get to the kind of what would I change about the landscape that we have? And that would be a very long list. But I think probably, firstly, transparency. Claimants need to understand what this means, not in a complicated way, buried in 30 pages of documents they have to sign at the start of their case. They need a fact sheet. They need a real life example of it, because that's how they understand and the gravity of what's going on. And when we're talking about reassuring them and persuading them to bare their soul, they've got real life, straightforward example of why it's really important. And so I think as well, we talked about defendants being held to account. I think a real understanding across the board of how much scrutiny is important, because as lawyers, we're representing that claimant. I'm working in their best interests. And so we've got to be doing this scrutiny and this review and recording. So I think there's two answers. Where's it going? Probably more cases, more guidance. Where would I like it to go? More penalties if it's alleged without much basis, and more straightforward information in front of claimants, because they really, really need that to get a grasp of it without descending into legal jargon, which is probably what I've just done.
Yeah, I think you've done a really good job of explaining all of that. And I guess, and for me, I probably would have mentioned this in the outro, but I'm going to mention it now, is I'm trying to reframe scrutiny as it's not a threat. It's actually, it maintains robustness in this process. And for me, scrutiny shouldn't be seen as like, oh God, this is it, I'm in trouble. It's a very relevant and important part of this process. And we should, hopefully, it's a message for our listeners that it's not something we should necessarily be frightened of, but embrace, ensuring that there's a robustness to how we are making sense of the lived experience of the people we work with.
Well, I guess it goes back to, again, the matter of fairness, doesn't it? And being fair to everyone and protecting everyone involved. We shouldn't be scared of showing our working out and being very clear about the decisions we're making and why. And if anything, that's our biggest tool, isn't it? To kind of avoid getting into any kind of difficulty in this respect. Lois, go on, sorry.
No, I was just going to say, replace the word scrutiny with thorough. You're being thorough. You should be thorough. And being thorough allows me to be robust, because I'm not scared of anything the defendant's going to pull up, because I've been thorough and I've done that. So replace scrutiny with thorough, I guess.
I love that. Yeah, let's be thorough. Speaking of thorough, I think we've done a thorough job of. I think you've done a thorough job of covering this topic, Lois. I think you've helped demystify it and make it more accessible for us. So thank you for that. Ben and I were talking about this question that we come back to each episode, because this is a podcast on rehabilitation and recovery primarily. So I'd be interested to know, from your perspective, from a lawyer's perspective, what does rehabilitation mean to you?
Well, I mean, rehabilitation is pretty much everything in the claimant's case, because rehabilitation is evidence. It's evidence of what's happening on the ground. When I said earlier, I go and sit on someone's sofa in my suit with my heels, I'm not in there. I'm not seeing the day-to-day reality of it. And I rely massively. The first thing I read in a case is records, because those case management notes or those speech and language therapy notes or physio or psychology notes, that's what gives me the real case. So when I spoke about before a claimant being raw and vulnerable and real, where do I see that from? Mainly their rehabilitation notes. That's the biggest insight. And if it's the biggest insight for me, it's probably the biggest insight for the judge as well. So rehabilitation to me, when looking at a case, is probably the best body of evidence I have that I can put before a judge.
Yeah, and I guess and that's a really helpful lawyer's perspective. And I know, Lois, just from seeing what you do on LinkedIn, you're involved in lots of different charities. And I wonder if you wouldn't mind me asking, what have you learned most about being involved in these type of cases and working with this group of survivors over the years?
Yeah, absolutely. I mean, I came into this job a little bit blind, I think, about the realities. And in particular, I work with spinal cord injured people, and what opened my eyes the most, to give a real life example, was that in 2025, somebody with a spinal cord injury may not be able to have access to a cervical smear or a mammogram because of their injury. And so what opened my eyes most in this job generally, and because of the links I've made in this job, is how healthcare remains a massive inequality problem. Um, and we have the Equality Act, but we're 15 years after it, and somebody can't get a cervical smear because they have a spinal cord injury. It's mind blowing. It feels like it can't be real, but sadly it is.
We need to do better on that, don't we?
We do. And we will.
Great. Well, thank you for that, Lois. What's the best way of people finding out more about your work or contacting you, or where are you most active if you are active on any social media platforms?
After all my social media warnings earlier, I only really use LinkedIn now. So I'm not on anything else. But, there's barristers, we were talking before we started about how people see barristers as a little bit scary sometimes. There's a brilliant body of legal people out there doing, posts and podcasts and blogs and putting really accessible information about. So, yeah, I'm LinkedIn, but there's lots of people doing brilliantly accessible things similar.
So one final question, Lois, before we end is, we're in a world full of misconceptions, and I suppose when people present in certain ways, like barristers, for example, they put across a certain, people might develop a certain perception of what type of people barristers are. I'm sure it's laden with misconceptions. What are some of the misconceptions that you perceive about the bar that you think people should know about?
Yeah, absolutely. And I think there are misconceptions about the bar, but I think they're fair because they're misconceptions that I held before I came to the bar. So I didn't have family in law. My parents hadn't gone to university, albeit they are the most class people in the world, and university couldn't have made them any better in any way. But I think the misconception is that the bar looks a certain way. And that's probably been caused by media and books and all of that. And also it's probably been caused by the realities of the bar a while ago, it was a male-dominated, Oxford, Cambridge-dominated profession. And that's not true anymore. It's still there. Of course it's there, like in every role, but we're working massively against it. So when I started this job, I used to either not speak or speak in a ridiculously posh voice that my old chambers mates will tell you about and tease me about. And, I've still got a bit of a court voice, but there's some northern there that comes through. And that you have to look a certain way. So I remember somebody saying to me, "Oh, I wouldn't start pupillage with your hair that blonde." And the worst thing is I listened to that because I thought it mattered. And we talk massively about imposter syndrome. I have imposter syndrome now, and I'm a fairly confident person because I'm lucky with the people around me who feed me to be comfortable in myself. But imposter syndrome is still real. And I remember a few years ago, I had a mentee who said to me, she wasn't my mentee at the time. She was somebody who I saw on a training weekend. She said, I don't think my face fits. And she had a very strong regional accent, and she was incredibly glam. And most importantly, she was incredibly talented. And I had to pep talk her and say, "What are you on about? I fake tan every Thursday night. I look a certain way, I talk a certain way, but I'm good at my job." And if I could get rid of one of the myths about the bar, it'd be that you have to look or sound a certain way, because it must put people off. And it shouldn't, because actually you can be however you want as long as you're good at the job. none of it matters.
It's got to be the most important thing, doesn't it? That's so refreshing to hear, Lois, because honestly, like, imposter syndrome is such a thing for me and for so many other people as well. I mean, thinking about this podcast in itself, when Ben and I were talking about setting it up, I had and I still do have the imposter syndrome. Am I really qualified enough to be sitting here having these discussions? Surely there's someone better out there to do this than me. But I guess naming that helps, because we're all the same. We all want to do a good job. We all want to be the best that we can be. And it's nice to hear that you guys are human too.
Absolutely. Absolutely. And to tail end that, the mentee that I was talking about became a barrister the year after. So, you know, it goes back to everything I say in this, transparency. And yeah, we are normal, I promise.
Transparency, authenticity, and integrity. Those are the 3 words that I'm taking away from this today, I think.
Absolutely.
And thanks so much, Lois. I think you doing something like this hopefully reduces our misconceptions further, and we just massively value your time and your thoughts on this. I found it really interesting. Hopefully other people have, and it just helps us all understand these 2 words that keep popping up or might pop up a bit more in the future, as you've said. So a massive thank you from me.
Thank you for having me.
So that was an excellent second half from Lois. And listening back to it now, Patrick, I think the key take-homes for me were very much around, Lois kept referencing the word thorough, and I really like that. I think this topic can cause a lot of anxiety for people, and it's coming up more and more. And I think what I'm taking away is that need to be thorough, that we all have a role in being thorough. And the big reflection on, like, that news story we spoke about right at the beginning, Stephen Naylor, you know, we have a responsibility to be thorough, to avoid situations like that where, sadly, for a variety of reasons, people might feel it's okay to be fundamentally dishonest. And it's a real shame, you know, cases like Stephen Naylor's, because I think for people who have complex injuries or difficulties that are either difficult to share or hard to see, particularly in brain injury, and we're going to talk more about things like the frontal lobe paradox in future episodes, I think that's even more important. So yeah, my key take-homes are around that kind of thoroughness, good note keeping, and and working with the client to understand their unique set of problems. What about you? What were your take-home messages?
You know, you talk there about the detail and being thorough. The devil very much is in the detail with these things, isn't it? And that's obviously what the lawyers are there for, to pour through that detail and to gather that evidence. And as clinicians and case managers and therapists, it's our role to provide really detailed records and to provide justification for things that are being done, but also explanations for why your client might be behaving in a certain way legitimately, you know, because there are instances where dishonesty might be raised as a question mark where there is a perfectly legitimate explanation. So yeah, thoroughness, detail, but also, you know, we talked right at the end of the episode about those 3 words that stood out for me: transparency, authenticity, and integrity. And I think we need to live by those 3 words.
Yeah, and I really hope listeners have enjoyed that 2-part series. I think for me, Lois not only did a fantastic job of breaking down that topic and making it accessible for therapists who are gathering evidence or sharing evidence as part of a civil litigation claim, but also I think she did a great job of demystifying some stuff around barristers. And thank you, Lois, for just bringing your authentic self to the conversation and sharing some things about you. I was particularly struck about how Lois has both benefited from mentors and now supports mentees in their development. And I really hope people got something from that around imposter syndrome, around believing in themselves, being confident in their skills and knowledge, and that transcending an image or a perceived image that you feel you should have in order to do the work that we do.
Yeah, 100%. It's so reassuring to me to know that people like Lois also experience imposter syndrome, because I think it's just a human thing. Especially when you really care about what you do and you want to do a good job. So yeah, thank you to Lois, and thank you to you, our listeners, for joining us and being part of these important conversations. Slightly different subject matter over these last 2 episodes, but hopefully they've been enlightening for you. And we'd be really keen to hear from our listeners about other topics that are maybe slightly left of field that you'd like us to cover, because ultimately we want to cover a really broad range of topics If you have enjoyed today's episode, please like, follow and share the podcast wherever you get your podcasts. It helps us reach more people and grow our community. You can connect with us on LinkedIn at the Listening First podcast for updates, discussions and more, and on other social media platforms too. So if you have any questions, suggestions for topics or guests, or you just want to share your thoughts, reach out to us on LinkedIn or email us at listeningfirstpod@gmail.com. So until next time, thanks for being with us as we keep learning, keep sharing, and most importantly, keep listening first.